Any mention?
Yes.
May it please, my lord, I beg to mention item 8.
Making a mention on behalf of the state.
Yes, my lord.
When do you want it?
After pujas?
Okay, item 8 on the request of the London Council for the state respondents. List is matter after 2 weeks.
Deeply obliged, my lord.
May it please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 1.
Item number 1.
Yes, Your Lordship.
I'm for petitioner.
You are for the respondent.
Yes, Your Lordship. Let the matter be come up after 3 weeks, Your Lordship.
Why?
Due to some personal difficulties, Your Lordship, my senior counsel will be out of station for.
This is against the bank. Service
bank,
matter.
bank.
Service matter.
Yes, Your
Dismissal from service. Out of station.
Out of station. No objection. Okay. There is only how many respondents are there? 7 others. Meghalaya state. There are many respondents. State is also a party here.
No, state, I don't think. Only the bank.
You are appearing for which respondent?
For the bank, Your Lordship, Meghalaya Rural Bank.
Which their respondent number what? How many respondents are there? There may be.
Your Lordship, on behalf of all the
You are an advocate on
respondents.
record. Your name appears here.
Yes, Your Lordship. On behalf of all the respondents.
All the respondents.
Oh. All the bank officials.
On the request of the London Council for the respondents, this matter after 3 weeks.
2 weeks, Your Lordship. Highly.
May I please, Your Lordship?
Yes.
Item 9, my lord. I'm for the respondent number 2, my lord. The victim's father, my lord.
I've got a petitioner, Your Lordship.
No objection.
No objection, Your Lordship.
When do you
My
want
lord,
it? For the state. When do you want it?
my lord, after puja vacation, my lord.
Okay, it will go after item 9.
9, my lord.
You are for the private respondent.
Yes, my lord. The victim's father, my lord. 2.
Yes, you just say on the prayer of the London Council for the private respondent. List this matter after 2 weeks.
My lord. Hello, my lord.
Yes, Mr.
I'd like to mention item 3, my lord.
That bank matter.
Bank matter, my lord. It's not purely a bank matter, my lord. It's something regarding the my lord,
Publication
declaration
of-
publication of defaulters list.
What remains here in this matter now?
My lord, here the,
has been made.
the
Can we
very,
recall?
the very
Undo
process
this.
of declaring the petitioner as default is under challenge.
No, that is okay. But then if it is done also, you have seen your prayer in the writ. Nothing remains.
We are seeking the quashing of the entire process. I mean, the orders, my lord.
Nothing remains. If you quash also, what relief will come? If we grant you the prayer which you
At least I'll be absolved of that tag, my lord. The defaulters, willful defaulter. It's not a defaulter only, my lord. It's a willful defaulter.
you have already, I think, repeat also.
He has repaid a very, the outstanding is more than 1 crore 44
But then he has
lakhs.
repaid
And
part
they have
of-
lost the case, Your
We
Lordship.
have
Here
repaid,
in
we
the
have repaid a part, my lord.
other bench.
1 crore is by virtue of interest being compounded.
No, they have not repaid, Your Lordship. They may have repaid some
that is
amount,
a-
but that is not the
subject matter.
subject matter of this matter.
But then here,
But
what?
he is a defaulter.
My lord, we are challenging the process by which, my lord, we have been held as a willful defaulter, my lord. Because there is certain procedure which is required to be followed before declaring somebody as a willful defaulter.
Who is there is a provision for
Provision.
declaring that?
There's a rule,
There's
RBI
a
guidelines.
Your Lordship,
RBI
and they are-
guideline that
which
needs to be
doesn't have
followed.
any statutory force at all.
Maybe, my lord, but,
It's just a
but that
policy
cannot
matter.
come from a bank. RBI guidelines are very much binding on the banks, my lord. It's not that.
But then the
and there
prayer
are
is
various
such-
judgments of the various courts, my lord, where only because, my lord, the RBI guidelines were not followed, my lord, the orders declaring somebody as a willful defaulter has been quashed by the other high courts, including Gujarat High Court.
Willful defaulter. That means what? That if until a person is declared a defaulter, Bank cannot initiate recovery proceeding.
Defaulter
We have
is one
already
thing, my lord. Willful
we have
defaulter is another
initiated
thing.
recovery.
Not
In
that-
order to come to a conclusion, my lord, that somebody is a willful defaulter, my lord, the bank has to establish that he has the capacity to pay but is not paying. That has not been done in this case.
That is their perception,
Additional-
Your Lordship. Our policies and the
If
rules.
that be the issue, then we can
procedures-
take up and decide the things. It will not be.
Only my difficulty, my lord, here again, the senior counsel is leading us in this matter. My lord. He has some personal difficulty,
You can take
lordship.
up the matter. You can argue by yourself. What is it?
I absolutely follow, my lord. Here, well, I have a very limited instruction.
you have
at
argued
least
the
for
matter
today,
also.
my lord.
Yeah, more or less, he
At
has
least for
finished.
today, my lord. He has some personal difficulty, so he's, my lord, in fact,
I'm not-
instructed me to have. You know, I've already expressed my lord, difficulty to.
On many
to the
occasions, I have
CA
prayed
here.
for time, Your Lordship, but today I'm not pressing because I understand Mr. Kostopal's difficulty since the puja is just
yes,
round the
yeah.
corner.
Okay.
Just round the corner, so I'm not.
Okay. On the request of the learned counsel for the petitioner, release this matter after 2 weeks. We'll do 2 weeks. We'll do
2
2
weeks
weeks.
is good enough.
A similar pair for 7, my lord. Here, it's a quashing petition, my lord, under 482.
Yes, okay, no problem. Is there 23 matters? Not much problem. You are for the petitioner here.
Petitioner.
Any objection? There is no interim order, perhaps.
There's no interview.
Anyway,
Oblige.
this is on the request of the learned counsel of the petitioner. List after 2 weeks. Just record the presence of the other side.
Please, Lordship.
Yes.
I beg to mention item number 4, Lordship.
Yes.
456.
456, Your Lordship.
It's not the 5. Yeah, this. 456. Yes, 456.
You are for the respondent.
Respondent number 4, Lordship. I have
These
responded.
are all related matter.
Yes, Your Lordship.
What are the matter?
The question, charge sheet already filed. I think trial also has procedure.
When do you want it? You are private respondent.
Yes, Lordship.
Any objection?
No, Your Lordship.
After 2 weeks, Lordship.
No problem, Mr. Sulai.
I have no objection since they are not.
Yes, Mr. Shankareshu.
Madam, it's a prosecution matter after puja, madam. Hopefully they will do
It's all
so.
right. There is no problem. These are not very old matters.
Not all
What
matters.
is problem with those matters which are usually like Susan of 2015, 16, and all this. Any item 4, 5, and 6. In all the matters, you are private respondent.
Yes, Lordship.
Will come after puja only, Your Lordship.
Yes. Miss Colony is with Mr. Shulai. Okay. On the request of the learned counsel for the respondents, release this matter after 2 weeks. 4, 5, 6.
Private respondent, Your Lordship.
Yes,
State
private
is
respondent.
seeking
Private respondent.
highly obliged.
Highly obliged, Lordship.
Obliged.
Main list, item number 2.
Yes.
Proceed. In these matters, earlier occasion we have argued the matters, but subsequent development is there, Your Lordship. My due area of salary already been paid. No grievance is surviving now.
So this can be closed.
It is.
Okay.
When party came and then I prepared the affidavit also if required I can give, but this petitioner says that her grievance is complete. She got the area salary. For which purpose?
So only we will say the grievance has been redressed. Okay. Mr. R. Devnath, learned counsel for appearing for the private respondents are also there. So we can close the matter on the basis of what the submission which has been made on behalf of the petitioner. Is it okay? Anyway, on Mr. R. Devnath, learned counsel appear with the petitioner, submits that the grievance raised by the petitioner in this petition has already been redressed, and the petitioner does not want to press this application. Stop. The petition. No, just in view of the submission, this writ petition stand dismissed. as not being pressed. That is there any use? Mr. Respondent has filed some affidavit as number 10, but then once you are withdrawing, I don't think there will be any relevance of that. You do one thing, just say.
So it should be instead of dismiss, that's it. Let it be withdrawn by me.
Huh? You will withdraw?
Because my grievance already addressed, so better to.
You do one thing, just anyway, just before that, just before starting at this thing, and reply affidavit. A reply to the additional affidavit filed by the petitioner has been filed with the respondent number 10. You start like this, okay? Then you say, Mr. R. Devnath, Learned Counsel appearance for the petitioner submits that. Right. Stop it. Then you say, as such.
Even Your Lordship, it may be mentioned that against this respondent number 10, private who filed the affidavit, I don't have any grievance against him.
This we are not required at all. Once you withdraw, representative proceed. Stop. Accordingly, he makes a prayer for withdrawal of the petition. Stop. In view of the submission, this writ petition stand dismissed on withdrawal. Okay, that's it. Yes. Thank you.
Item number
Old
10.
cases getting disposed of.
This already salary has been released and accounts.
That's it.
10.
Please, Your Lordship. Lordship, this is an application under Section 482 CRPC, my Lord.
Yes.
For quashing of an FIR.
Yes. Carry.
Lordship. My Lord, the FIR was an offshoot of a civil dispute, my Lord. So what has happened here, my Lord?
Yes.
The crux of the matter is that the dispute broke out between the Chras and Maharis of the Nukma, Lungalgre, my Lord, with the son of the Nukma and the respondent number 2, my Lord. So thereafter, my Lord, she filed a complaint before the Lungalgre outpost, and that on that same day itself, she submitted a...
What is the allegation in the complaint?
354-506-34.
And how do you say it is civil dispute?
No, it was an offshoot, my Lord. Offshoot of a civil dispute.
That is your submission, but then there is nothing to say. Anyway,
Lordship.
Go ahead.
No, then what has happened, my Lord?
That is the background of your submission.
That is the background of my submission, my Lord.
Yes.
So what has happened, my Lord, thereafter? She filed a complaint, my Lord, before the Lungalgre outpost. And on that same day itself, she submitted a compromise letter, my Lord. Kindly come to annexure number 1, my Lord.
Just take us to FIR first, then we'll come to compromise.
No, my Lord. This is the first complaint, then compromise, then again an FIR was lodged after 26 days, my Lord.
Complaint, compromise, then FIR.
FIR. Yes, my Lord. That is why I'm coming with the compromise first, my Lord.
Annexure 1.
Annexure 1. Page 11, my Lord.
Yes.
Then this is the translated copies at page 30.
Yes.
So if I may be permitted to read, my Lord. We on this 4th day of August 2021 on behalf of the Forest Department has visited Lungalgre, and in the process we had some misunderstanding with Crosspill Sangma, and I had an argument with him because he used derogatory words against me, and in the heat of the moment I slapped him. In fact, she was the one who slapped one of the stars, my Lord. But now we both the parties unanimously agree and had forgiven each other. After this, my Lord.
No, why it was filed to the officer in charge?
No, because she filed a complaint on that day itself, my Lord, and she filed this compromise on that same day.
But then this compromise is in reference to which complaint?
Oh, my Lord.
This is basically the annexure which you have read out. You have read out just now.
Lordship.
What is this? It appears to be a compromise.
Lordship. She did not file a written complaint, my Lord. She just filed a verbal complaint. Then after that, she submitted this compromise, my Lord. Then after 26 days, my Lord, she again filed an FIR, best known to her, my Lord. Kindly come to annexure 16, my Lord. Oh, no, annexure 14, my Lord. This is the FIR, my lord.
Yes.
Page 14. Now here she's narrating a different story, my lord.
Yes.
If I may be permitted to read, my lord, from para number 1.
Yes, yes.
That on 4/8/2021, at around 4:38 p.m., I was proceeding towards Shedding on scooty bearing such and such, driven by my friend Sri Ben B. Marak. As I myself was not able to drive the scooty due to recent major operation on my thigh, I requested him to drive me to Shedding. Hence, we were proceeding. That on reaching along the Ampangre area, all of a sudden, some persons, all male, came in auto rickshaw and one bike, and 2 persons, which Sri Grossfield De Sangma and Sri Tony Tojang Marak, blocked our way at National Highway ahead of us, and we halted the scooty, on which Sri Brilliant Brandy B. Marak snatched the key from the scooty and pushed the driver of the scooty to the side of the road. And all of a sudden, 2 men hold my both hands, one each, and one hand at Sri Gospel De Sama, caught my breast from the front without giving any chance for realizing what is going. 2 more person who came on the bike, Sri Polanti Sama, Sri Gilman and Sama, punched me at the back, and my hands were twisted to backside of me, giving me pain, and the recently operated left thigh wound suffered severe pain and later on sustained swelling, and wound deteriorated. While attacking me, I could hear them telling them to each other to finish off my life and throw me on the roadside jungle. These all incidents occurred in such a short moment which could neither be defended nor sought for help from anywhere, but I was in shock and trauma to realize the incident. Later on, I noticed that one of my gold ring from my one year also went missing at the incident, which I could not recover it from the spot. Then seeing the approaching other vehicles, they released me from their clutches, warned me sternly to finish off my life if I report the matter to the police, and drove away the auto rickshaw and bike, leaving me in pain, and my friend was also still there at the roadside, shocked. Then after the incident, I was shocked and trauma. I was also fearing being publicized, due to which took me several days to gather courage to come forward and report the matter before your kind office. This is in respect of the same incident, my lord. Then thereafter, my lord, they again came with a compromise, my lord. Kindly come to annexure 4, my lord. Page 48.
This matter has been charge sheeted.
It has been charge sheeted, my lord.
This case has been registered under what section?
354, 506, and 34, my lord.
$354 is not compoundable.
No, it's not compoundable.
Yes, page 48.
48, I think relevant portion would be at page 49, my lord. I'll start from para 2. Then the spirit of reconciliation, compromise, and cooperation, Srimati so-and-so will withdraw the criminal case against so-and-so, son of Crossville at William Nagar, FIR number 18/8/2020 under section 34, 506, 34 IPC, now case number such and such, my lord. And kindly come to para 3, it is a relevant portion, my lord. Undertakes to withdraw all objection to the concerned authorities to stop all agitation and obstruction to work together with Amache Sangma and so-and-so to ensure that the process of land acquisition for the BSF is smooth and completed without further delay. This is the main source of the issue, my lord.
Yes.
The 322 acres of land, my lord.
Then, who is for private respondent? Who is appearing for private respondent?
We served them notice, my lord.
No,
she did not turn up, my lord. Then again we serve another notice, my lord. She was aware, but she is not before this honorable court, my lord.
No, but then this is as per the agreement. She has to withdraw, and if she doesn't do it, then
Lordship, she doesn't want to proceed with the
even
matter.
if you say it is a compromise,
Lordship,
354 is there.
I do agree, my lord. That is why I'm relying on some judgments, my lord. I'm relying on some judgments, my lord. My lord, first judgment is 2008 for SCC 582, Madan Mohan Abbott versus State of Punjab, my lord.
Yes.
Kindly come to page 2, my lord.
Yes.
Para 5, relevant portion, my lord.
Yes.
It is on the basis of this compromise that the application was filed in High Court for quashing of proceeding, which has been dismissed by the impugn order. We notice from our reading of the FIR and other documents on record that the dispute was purely a personal one between two contesting parties, and that it arose out of extensive business dealings between them, and that there was absolutely no public policy involved in the nature of the allegation made against the accused. We are therefore of the opinion that no useful purpose would be served in continuing with the proceeding in the light of the compromise, and also in the light of the fact that the complainant has on so and so passed away, and the possibility of conviction recorded has thus to be ruled out. We need to emphasize that it is perhaps advisable that in disputes where the question involved is of a purely personal nature, the court should ordinarily accept terms of the compromise even in criminal proceedings, as keeping the matter alive with no possibility of a result in favor of the prosecution is a luxury which the courts, grossly overburdened as they are, cannot afford, and that the time so saved can be utilized in deciding more effective and meaningful litigation. This is a common sense approach to the matter based on ground of realities and bereft of the technicalities of the law. Then another judgment which I am relying upon, my lord, is 2014, Narinder Singh and others for State of Punjab, my lord. Here also 507 has been 11, as your lordship is very much aware. The relevant portion will be at page 24, my lord.
Page 24.
My lord.
How many judgments you have?
I'm relying on.
No, how many judgments you have? This is
a compilation of judgments, my lord.
How many judgments are there?
6 judgments, my lord. Page 24, my lord.
Yes.
The relevant portion would be from para 29, my lord.
Yes, please go. Go ahead, no problem. Go ahead.
In view of the aforesaid discussion, we sum up and lay down the following principles by which the High Court would be guided in giving adequate treatment to the settlement between the parties and exercising its power under Section 482 of the Court while accepting the settlement, quashing the proceeding, or refusing to accept the settlement with direction to continue with the criminal proceedings. Power conferred under Section 482 of the Code is to be distinguished from the power which lies in the Court to compound offences under Section 320 of the Code. No doubt under Section 482 of the Code, the High Court has inherent power to quash criminal proceeding even in those cases which are not compoundable, where the parties have settled the matter between themselves. However, this power is to be exercised sparingly and with caution. When the parties have reached the settlement and on that basis petition for quashing the criminal proceeding is filed, the guiding factor in such cases would be to secure, number one, ends of justice, or to prevent abuse of the process of any court. While exercising the power of the High Court is to form an opinion on either of the aforesaid two objectives. Such a power is not to be exercised in those prosecutions which involve heinous and serious offence of mental depravity or offences like murder, rape, dacoity, etc. Such offences are not private in nature and have a serious impact in society. Similarly, for the offences alleged to have been committed under special statute like the Prevention of Corruption Act or the offences committed by public servants while working in that capacity are not to be quashed merely on the basis of compromise between victims and the offender. On the other hand, these criminal cases having overwhelmingly and predominantly civil character, purely those arising out of commercial transaction or arising out of matrimonial relationship or family dispute, should be quashed when the parties have resolved the entire disputes among themselves. While exercising its power, the High Court is to examine whether the possibility of conviction is remote and bleak, and continuation of criminal cases would put the accused to great oppression and prejudice, and extreme injustice would be caused to him by not quashing the criminal cases. Offences under Section 307 IPC would fall in the category of heinous and serious offences, and therefore are to be generally treated as crime against society and not against the individual alone. However, the High Court would not rest its decision merely because there is a mention of Section 307 IPC in the FIR or the charge is framed under this provision. It would be open to the High Court to examine as to whether incorporation of Section 307 IPC is there for the sake of it, or the prosecution has collected sufficient evidence which, if proved, would lead to proving the charge under Section 307 IPC. For this purpose, it would be open to the court to go by the nature of injury sustained, whether such injury is inflicted on the fatal, delicate parts of the body, nature of weapons used, etc., medical report in respect of injuries suffered by the victim can generally be the guiding factor. On the basis of the prima facie analysis, the High Court can examine as to whether there is a strong possibility of conviction or the chances of conviction are remote and bleak. In the former case, it can be refused to accept the settlement quashing the criminal proceeding, whereas the later case, it would be permissible for the High Court to accept the plea compounding the offence based on complete settlement between the parties. At this stage, the court can also be swayed by the fact that the settlement between the parties is going to result in harmony between them, which may improve their future relationship. While deciding whether to exercise power under Section 482 of the Code or not, timings of settlement play a crucial role. Those cases where the settlement is arrived immediately after the allegation commences the offence and the matter is still under investigation, the High Court may be liberal in accepting a settlement to quash the criminal proceeding investigation. It is because of the reason that at this stage the investigation is still on and even the charge sheet has not been filed. Likewise, those cases where the charge sheet is framed but the evidence is yet to be started or the evidence is still at infancy stage, the High Court can show benevolence in exercising its powers favorably. But after prima facie assessment of the circumstances material mentioned above, on the other hand, where the prosecution evidence is almost complete, or after the conclusion of the evidence, the matter is at the stage of argument, normally the High Court could refrain from exercising power under Section 482 CRPC of the Code. As in cases, the trial court would be in a position to decide the case finally on merits to come to a conclusion as to whether the offence under Section 307 IPC is committed or not. Similarly, in those cases where the conviction is already recorded by trial court and the matter is at the appellant stage before the High Court, mere compromise between parties will not be ground for accept the same result in acquittal offence of the offender who has already been convicted by the trial court. Here, charge is proved under Section 307 IPC and conviction is already recorded in heinous crime. Therefore, there is no question of spare and convict found guilty as such a crime. My Lord, thereafter, I'm also relying, my Lord, 2014 SSC online Rajasthan 220 of 2209, my Lord. This is actually a High Court judgment, my Lord. May not have a bearing, but for the reference of this Honorable Court, I'm just relying on this judgment as well. Kindly come to page 33, my Lord. The relevant portion will be at para 11, 12 and 13, my Lord. The Honorable Supreme Court in the cases of Jairaj Singh, Digvijay Singh Rana and versus State of Gujarat reported in 2012 CRL SC 743 held as under. In such bona fide circumstances, the power under Section 482 may be exercised. Further, in view of the settlement arrived at between respondent number 2, the complainant and the appellant, there is no chance of recording a conviction insofar as the present appellant is concerned, and the entire exercise of trial is destined to be an exercise in futility. In as much as the matter has not reached the stage of trial, we are of the view the High Court, by exercising inherent power under Section 482, are of the view that of the Court, even in offences which are not compoundable under Section 320, may quash the prosecution. However, as observed in CG Supra, the power under Section 482 has to be exercised sparingly and only in cases where the High Court is for reason to be recorded of the clear view that continuance of the prosecution would be nothing but an abuse of the process of law. In other words, the exercise of power must be of securing the ends of justice, and only in cases where refusal to exercise the power may result in the abuse of the process of law. The coordinate bench of the court in the case of B.S. Tomar versus State of Rajasthan held as under. Considering the fact that the offence alleged against the petitioner is more in the nature of personal wrong rather than a threat to the society at large, considering the fact that the parties have entered into compromise, this court is of opinion that the offence under Section 354A, 354D and 370 IPC are compounded. Consequently, the petition is hereby allowed and the FIR number such and such for the offence under Section 354A, 354D and 370 IPC is hereby questioned set aside. Another judgment which I am relying upon, my Lord, is Jasprit Singh Golu versus State of New Delhi, my Lord. This is a judgment of New Delhi, my Lord, of High Court of Delhi, my Lord. The relevant portion will be at page 38. Starts from para 9, my lord.
Yes.
It is a settled law that the inherent power of the High Court under Section 482 CRPC should be used sparingly. The Honorable Apex Court in the case of State of Maharashtra through CBI versus Vikram, Antarya, Dosi and others, Manu, and in the case of Inder Singh Goswami versus State of Uttaranchal, has observed that powers under Section 482 CRPC must be exercised sparingly, carefully and with great caution. Only when the court comes to the conclusion that there would be manifest injustice or there would be abuse of the process of the court, if such power is not exercised, court would quash the proceedings. It is a well-settled law that where the High Court is convinced that the offences are entirely personal in nature and therefore do not affect public peace or tranquility, and where it feels that quashing of such proceedings on account of compromise would bring about peace and would secure ends of justice, it should not hesitate to quash them. In such cases, pursuing prosecution would be waste of time and energy. Non-compoundable offences are basically an obstruction in entering into compromise. In certain cases, the main offence is compoundable, but the connected offences are not. In the case of B.S. Joshi and others, the Honorable Apex Court observed that even though the provision of Section 320 CRPC would not apply to such offences which are not compoundable, it did not limit or affect the powers under Section 482 CRPC. The Honorable Apex Court laid down that if, for the purpose of securing the ends of justice, quashing of FIR criminal complaint becomes necessary, such Section 320 CRPC would not be a bar to the exercise of power of quashing. In the nutshell, the Honorable Apex Court justified the exercise of powers under Section 482 CRPC to quash the proceeding to secure the ends of justice in view of the special facts and circumstances of the case, even when the offences were not compoundable. In the light of the aforesaid, the court is of view that notwithstanding the fact that offence under Section 354 IPC is not a non-compoundable offence, there should be no impediment in quashing the FIR under this section if the court is otherwise satisfied that the facts and circumstances of the case so warrant. Then another judgment, my lord, is Taj and another versus State of Maharashtra. The relevant portion would be page 55, my lord. From para 15, my lord. In paragraph number 3, 4 and 5 of the criminal application, the applicants have jointly submitted narrated the facts. Looking at the contents of the criminal application, it appears that both the applicants have arrived at a compromise. Applicant number 2 has withdrawn the allegation against applicant number 1. Therefore, in such circumstances, continuation of the trial is nothing but a formality. If the said trial is held to be continued, then both the applicants, who are barely 19 years and 17 years of age on the date of incident, will have to attend a court, which would be meaningless exercise in futility. The offence committed by applicant number 1 is admittedly not a heinous crime or a serious offence like murder, dacoity or rape. Therefore, not allowing the compromise between the applicants would essentially mean continuation of the criminal proceedings and an abuse of the process of law, and therefore in the interest of justice, applicants ought to be permitted to compound the offences. Then para 17, my lord. Board of applicants are present court today on considering the pleadings, the totality of circumstances and the law laid down by the Honorable Apex Court. We are of the opinion that the criminal proceeding in the present case need to be quashed. Here the section level against the accused person was section 354A 1, 354D, 506B and section 7 and 8 of POCSO Act also, my lord.
Both the parties were present in the court.
Yes, my lord. But section 7 and 8 also level against the accused person, my lord.
See, this thing, different high courts has different opinion.
My lord.
Especially POCSO and all.
Yes, my lord. So I'm not pressing on that, my lord, because we are just on section 354 as of now, my lord. And this is from the Allahabad High Court, my lord. 2020 Allahabad High Court. Relevant portion would be at page 57, my lord. If Lordship fines like Sankar Yadav versus State of Chhattisgarh
Yes.
and Madan Mohan Nabat versus State of Punjab. I'll just read from that. In a recent judgment, my lord, if your lordship can see.
Yes.
In a recent judgment of the bench of honorable judges in the cases of Parbat Bhai Ahir was alias Parbat Bhai, Bhim Singh Bhai, Karmur and others versus State of Gujarat and another reported so and so. Honorable Supreme Court has summarized the ratio of all the cases decided earlier with respect to quashing of FIR, charge sheet, criminal proceeding on the ground of settlement between the parties and expounded of the 10 categories in which application under Section 482 can be entertained for quashing. The FIR, charge sheet, criminal proceeding on the basis of the compromise. Para 15. Section 482 preserves the inherent power of the High Court to prevent an abuse of the process of any court or secure the ends of justice. The provision does not confer new powers. It only recognizes and preserves powers which inhere in the High Court. The invocation of the jurisdiction of the High Court to quash a first information report or a criminal proceeding on the ground that the settlement has been arrived at between the offender and the victim is not the same as the invocation of the jurisdiction of the purpose of compounding an offence. For compounding an offence, the power of the court is governed by the provisions of Section 320 of the Code of Civil Procedure. The power to quash under Section 482 is attracted even if the offences is non-compoundable. In forming an opinion whether a criminal proceeding or complaint should be quashed in excess of its jurisdiction under Section 482, the High Court must evaluate whether the ends of justice would justify the sub-inherent power. While the inherent power of the High Court has a wide ambit and plenitude, it has to be exercised to secure the ends of justice, to prevent an abuse of the process of any court. The decision as to whether a complaint or first information report should be quashed on the ground that the offender and victim settle the dispute resolve ultimately on the facts and circumstances of each case, and no exhaustive elaboration of principles can be formulated. In the exercise of the power under Section 482 and while dealing with the plea that the dispute has been settled, the High Court must have due regard to the nature and gravity of the offence. Heinous and serious offences involving mental depravity or offences such as murder, rape and dacoity cannot approximately be quashed, though the victims are or the family of the victim have settled the dispute. Such offences are truly speaking not private in nature, but such a serious impact upon society. The decision to continue with the trial in such cases is founded on the overriding element of public interest in punishing persons for serious offences. As distinguished from serious offences, there may be criminal cases which have an overwhelming or predominant element of a civil dispute. They stand on a distinct footing insofar as the exercise of the inherent power to quash is concerned. Criminal cases involving offences which arise from commercial, financial, mercantile partnership or similar transaction which an essentially civil flavour may be appropriate situation full for quashing where parties have settled the dispute. In such a case, the High Court may quash the criminal proceeding if in view of the compromise between the disputants, the possibility of a conviction is remote and the continuation of a criminal proceeding would cause oppression and prejudice. There is yet an exception to the principle set out proposition 7 and 9 above. Economic offences involving the financial and economic well-being of the state have implications which lie beyond the domain of a mere dispute between private disputants. The High Court would be justified in declining to quash whether offender is involved in an activity akin to the financial or economic fraud or misdemeanor. The consequences of the fact complaint upon the financial economic system will weigh in the abundance. In view of the aforesaid pronouncement of the Honourable Apex Court and in the light of the compromise arrived between the parties and its verification done by the court below ascertaining the willingness of the parties to settle the dispute amicably, the present application under Section 482 CRPC is hereby allowed and the entire proceedings under criminal arising out of the case such and such under Section 354, 452, 323, 354B, 506 IPC is hereby quashed. Lordship, my case is that the entire genesis of the matter started from a civil dispute, my lord. So thereafter, altercation broke out between the Chas and Maharis of the Nukma with the respondent number 2. And it is evident from record, my lord, that she compromised on the day itself when she filed a complaint. Then after 26 days, my lord, she, for reasons best known to her, she again lodged an FIR, my lord. After that again, and it's evident from the compromise also, my lord, that the entire issue arose because of that. 322 acres of land. So at this juncture, my lord, I'm just praying that the criminal proceeding, the FIR may be quashed, my lord.
Yes.
May it please your lordship. Lordship, kindly see the FIR, the charge sheet. The charge sheet has been filed on 17/6/2022. 2007. So, Lordship,
Where is the charge sheet? At page?
Lordship, I will find at page 29. The charge sheet was filed on 17/6/2022. Now we are in the month of almost November 2023. So, what is the stage of the proceeding that has not been brought?
Yes.
Has not
What
been
is the stage of the proceeding, Mr.?
No, it seems like it has been stayed, my lord. It has not been proceeded, my lord, because of the pendency of the matter here, my lord.
How can it be?
That is my instruction, my lord.
Because the
last occasion also, the respondents, they contacted me, my lord, and they said like it has not been proceeded till date, my lord. That is my instruction. But if lordship wants, I can.
And that will be vital. You see, like at least
the magistrate, lordship, because to keep the matter in abeyance, because under the CRPC, your lordship, there is no provision which empower the magistrate to stay his own proceeding, your lordship.
No, because lordship, we have informed the court that we have filed an application under 482, my lord.
No, that is okay. But then, even in spite of that, the court cannot stay its own proceeding.
Lordship.
It can adjourn. It may adjourn a matter.
Lordship.
Okay.
No, it has not been. It has not stayed, my lord. I don't think it has been stayed, my lord. But
you cannot say the own thing, please.
Lordship,
that is what. See, like this court doesn't want to pass any foolish order. You see, like something like that, you pass an order, and later on you find the certain different situation is.
Lordship, I do agree, my lord.
So, what requires, especially you see, like as a council, you must have that. You see, like you must be responsible for giving.
Lordship. If that be the case, my lord, I can seek instruction whether.
And that has to be done then.
Or the record may be called, your lordship, to see what is this.
Why record? You don't want to burden, see, like.
Lordship.
Let him take the thing, or he may take the. He may obtain a copy of the latest order also.
According to him, information has been laid before the London trial court that a criminal for quashing petition has been filed before the Honourable High Court.
So let us see what order is there.
Your lordship, that will be reflected.
We'll see the latest order.
Latest order, my lord. Then we'll obtain the latest order.
Yes. Heard Mr. Ajib Momin, learned counsel of the petitioner. Also Mr. Andy Shulai, learned AG appearing with. It appears that the status of the trial. It appears that the stage of the trial, stage of the proceeding pending in the trial court is necessary for the purpose of deciding this matter. The learned counsel for the petitioner undertakes to obtain necessary instruction which regards to the status of the trial proceeding in the trial court and place the same before the court on the next date of hearing. When shall we reach?
Can happen on first, your lordship, first November.
Come after 2 weeks, we'll just say.
Lordship.
List this matter after 2 weeks to enable the learned counsel for the petitioner to place on record the status of the
trial
of the pending before the trial.
Apply, lordship. 10 to 14. Same
10 to 14, similar matter.
That's see, Mr. Shulai. Otherwise, if these things and if that private respondent is not interested also, why should we keep this matters proceedings? it appears that she
Lordship,
compromised, then she filed again FIR, then
Lordship will kindly see that she has given the statement before the police under 161. She has reiterated what she has stated in the FIR, Lordship. So if the trial is allowed to proceed, Your Lordship, we can summon her and cross-examine, Your Lordship. And she will be prosecuted for giving of perjury or false information.
But she has already filed a compromise, my lord. That is
because after all, 354, this is sexual offences, Your Lordship, which, in my humble and respectful submission, are not private in nature.
yes, definitely. That is one thing.
Lordship, I'll advance
different
my
High
argument.
Courts has given his different opinion, my lord. It's a personal, private nature, my lord.
That is one thing you see, like.
Lordship, I'm not pressing on that, but I'm just
Because so
for
far
reference,
the
my lord.
power of questioning, there is no legal dispute with that, Your Lordship. The fact that 354 is non-compatible, there is no legal dispute to that.
But lordship has to see the circumstances of the case also, my lord.
Because
She filed a complaint, then she.
Also, Your Lordship, that is happening had been recorded in a mobile phone. That mobile phone also has been seized by the police, Your Lordship.
That recording is also there.
Your Lordship.
Let that
status
thing
come,
is
Your
that
Lordship. I'll
if
advance my
the
argument.
person concerned has come to a settlement,
Lordship.
has entered into an agreement, why she is not coming forward to this court to say that she is compromised?
Lordship, I'll point out
That is the reason why, my lord, we had to file. Earlier, when we were supposed to file this application, we actually informed her to come before this court as well. As a joint petition, my lord.
So it seems there is no compromise there.
because
No, but she said that since she's already compromised, she has given it on writing, my lord. She doesn't want to
Here
come forward.
compromise said she will withdraw the case. What steps she has taken to withdraw? That means she's silent. That means she is not compromised.
Lordship, going by the
There are many ways to look at this, you see.
Lordship.
If somebody compromises and if a person is sincere, they will stand by it.
No, but there have been instances, my lord, wherein they have not come by way of a joint petition also, my lord.
No, it is not required. Why should we come by joint petition? There is no question of coming by.
But it's evident from record, my
But
lord,
when
that
there is a notice served upon a person,
Lord-
should come. In case of should come. This should not be something like that. That refusal of this thing. She has refused to accept the notice here.
lordship.
So
So we'll just obtain the instruction, my lord. I will leave it to your
you
discretion.
obtain the
my lord.
instruction. You
Yeah,
obtain
we'll
the
leave it to your
instruction.
discretion, my lord.
And meanwhile, also try to convince your thing. If she comes here, your thing will be easier here.
Lordship, we have convinced her. She said since she's already given out paper, my lord, she doesn't want to approach. Then we can't force her also, my lord.
No, you cannot force us. Definitely, there is no question of forcing her.
Lordship.
But then the thing is that if that compromise becomes doubtful, then
even the signature
she
also.
has compromised. She has the papers, but then she said in that paper she said that she will withdraw it.
The first compromise, my lord, it appears that she herself slapped the.
So that is why then in such a case, if compromise goes, then what remains in your?
And after on that same day, after 26, for reasons best known to her, my lord, she has filed an
If
FIR,
this
my lord.
compromise goes, then what remains? Then you have nothing. in this
Actually,
case.
the entire crux of the issue, my lord, arose
Face a
because of
trial.
that.
If you say that, you see, like in view of the situation here, the trial will not bring any result. You see a section 321 also where the prosecution can withdraw. It is not that all your remedial lies and 482.
No, my lord, but
If
it's a
your
non-
prosecutor is
compoundable section,
convinced,
my
prosecutor can always withdraw from the prosecution. Moment prosecutor finds that there is no evidence.
yes,
Will be withdrawn.
it's a
Why not?
non-compoundable section, my lord. That is why I'm coming before this honorable court, my lord.
And you take your chances, but then the thing is that you see, this court is not basically telling you that no, you cannot come by 482. You can come.
Your lordship.
We are talking about the relief, and especially if you say compromise and the person who is compromised is not coming to court, that is something you see becomes very suspicious. Then your compromise itself becomes question.
No, but from
Now, we do not know this compromise has been attained under what situation. It may be by duress, it may be by fraud.
if lordship goes into that aspect, of course, then of course,
Many suspicion may come, you see.
lordship.
482, you take a chance. You see, you do not have a right to say.
No, that I do agree, my lord.
Basically, you have to totally
No,
rely
but
on.
from records, my lord, it transpires that she has come into a compromise, my lord. That is why I'm before this honorable court.
But she has come. You see, if you see that, then you see the first thing we have shown that she has compromised before police station.
Lordship.
Then again she files FIR. Then again she compromised, and now again she is not coming.
But that is what I'm saying, my lord.
So you can say that she is basically neither here nor there, but then you cannot say that there is a settlement now. Then.
But should I leave it to your discretion so far as the...
Obviously it is a discretion.
Lordship.
See, it's a discussion. There is no question of these things. But then normally you see, like, the thing is that you see, like, your remedy is not always that you come to 482 and get the things. There are other remedies also available. Okay. Anyway, just take the instruction what happens with these things, and we'll see it. We'll see it after 2 weeks. Yes. There are other methods also thereafter.
That is
And this is the...
10 to 14 are analogous.
All these are connected matters.
Lordship.
Connected.
So all will be same order.
Same order. Same order will follow in the rest of the cases.
They are all similarly situated.
Yes, my lord. They are all Maharis, my lord.
Yes. Okay.
I'll apply.